you have an extra couple of minutes so I can smoke a cigarette while this is going on?
Yeah.
Charles?
You can smoke on... I like film noir, so if you want to add some film noir, that would be fine.
Mm-hmm. Keep rolling?
Yeah.
Okay.
What was that?
I just want to make sure you want me to stay rolling.
Oh, yeah. No, are we on Kent State? Thank you. Are we on Kent State now, or are we talking about something else?
No, we were talking... Charles, you may want to help Dad out. I was asking you a somewhat obtuse question, but I'm interested in procedure. And I was asking you why the Office of the Solicitor General was not involved in basically in defending the issue of executive privilege. In the tapes.
There was a problem about that issue, and Elliot put me in charge of negotiating for the department with Cox's outfit to try to arrive at a position that would not unduly cut into executive privilege. You couldn't tell them not to plead it, but we tried to. And Phil Lacavara and I met a couple of times. There was no principled way to say that executive privilege does not apply in this case, but it did in other cases. So he said he would make as narrow an argument for an exception to executive privilege as he could. He did.
This is during
before the argument in the Supreme Court.
Oh, in '74.
Yeah.
Okay.
Well,
this is.
I was negotiating with him before that, in '73, because, it was before Elliot left office.
Okay.
Because the collision between executive privilege and the special prosecutor's needs was inevitable. It was approaching. You'd see it. And that's when Elliot asked me to try to work out a compromise.
Why don't you, if you want to light your cigarette. In 1973, when you become Solicitor General, what is the understanding of the ownership of presidential papers? What is what at that point when you become Solicitor? What was the sort of I guess it's common law view or the
I don't know.
legal?
I don't know. The truth is, when I came into office, I didn't immediately learn everything, and I don't know what the answer to that was. That is, that's not a subject in the constitutional law course at Yale.
But you had to very quickly get an opinion on that.
Well, not that one. I didn't.
Well, the tapes, presidential material.
Oh, the question of ownership. Well,
Yeah, ownership.
It isn't a question of ownership. It's a question of access to the information. You know, you can if somebody gets a warrant to search your house, you don't lose the ownership of your house.
True. You just get to look at your things.
Yeah.
Judge Sirica didn't really provide you any guidelines on that on executive privilege. I think he didn't even rule on that summer.
In a sense, there is no executive privilege. It's a governmental privilege, because every branch of government claims the same privilege. And calling it executive privilege sounds as if the president is elevating himself above the rest of the government. He's not. You try subpoenaing the conference records of a court, or try subpoenaing the records of a closed session of a congressional committee. You're going to get a claim of privilege. It's not executive. It's a governmental privilege.
when before we get to, tell us about any interactions you had with Archibald Cox when you were both professors.
None. I didn't know the man. I knew who he was, but I didn't know him. I read one article by him.
That summer, as you were watching, I mean, you did interact a little bit with his team. You mentioned about talking to Lacavara. How well did you think he was doing his job?
Cox? He was doing okay. He was very slow. He didn't do anything wrong, but he was not a prosecutor, and he agonized over decisions, which was just as well, because if you don't know quite what you're doing, it's just as well to figure it out. Now, Jaworski was a prosecutor, and he moved much more rapidly because he was used to that kind of stuff. He knew the doctrines, he knew which Cox didn't. And that's not Cox's fault. He just wasn't that kind of a lawyer. But I think he did a good job as far as he was allowed to go. The difficulty, the whole uproar was because Cox could be fired for a cause, and there was no cause to fire him. That is not in the legal sense. So that's what caused the uproar. That is, I say there's no cause to fire him. There was no, within the meaning of the charter, there was no cause. The reason for firing him was facing down the president in national television. You can't have a subordinate officer facing the president down on national television, particularly, as Haig kept pointing out, at a time when the president's prestige was being challenged in the Middle East, where there were all kinds of things going on, and Nixon had to exert a great deal of moral authority as well as physical authority. So I think Cox had to be fired, but not because he was behaving improperly within the meaning of the charter.
What did you hear of the Stennis compromise during the week before this blew up?
I heard about the Stennis was going to listen to the tapes, and I thought it was somewhat hilarious because Stennis was. I met Stennis, and he was by no means vigorous enough, or his hearing wasn't good enough to make out those tapes. It was a way of putting the whole thing off. And I think at one point Cox sort of agreed to it and then backed away. I'm not sure about that. But the compromise, I thought, was a non-starter. In fact, I don't think there's anything that could have saved Nixon. We haven't even gone into the U.S. Attorney's Office had made the case against Nixon before Cox was even appointed. I had a 72-page memorandum given by Earl Silbert, who was an assistant in the U.S. Attorney's Office, to Cox, outlining the case. And I think Doyle's book quotes somebody as saying that the case was 90% made at that point. And beside Nixon's name in the memorandum, somebody had written, I can't find out who, somebody had written constitutional question mark. So, but let me explain this. It's the kind of thing I love and nobody else does. There was no jurisdiction in the case. The Supreme Court didn't have jurisdiction, but they weren't going to let that stop them. And there comes a time when the pressure is on sufficiently, when things like that just drop out of sight. But when there's a controversy between two persons, one of whom can end the controversy by issuing an order, there's no case or controversy, which the Constitution requires. Now, the same thing would have been true if the U.S. Attorney's Office had continued, which would mean, in effect, unless a state undertook to impeach the president, which I think you can forget about, which would mean, in effect, that there's no route in a case like that except impeachment. Now, when the case was argued, St. Clair, arguing for the president, didn't fully understand this argument about jurisdiction. And he said to the court, you can't have two people in the same branch of government suing each other and get a court determination of the difference between them. And Potter Stewart said, well, that's certainly true in the ordinary case, but here he has a charter. It was a charter I issued. So I listened to it. Now the answer to that is, if that were true, the president could turn every policy dispute within the government into a judicial question by issuing charters everywhere. And that's not going to work. St. Clair didn't make that argument. He just accepted the charter argument and went on. It's the only point they had. The only chance they had to win was that one. And I don't think it was a real chance, because I think you don't remember the incredible tension in Washington and in the country. And they wanted a resolution. And they didn't really care much how they got it. So I don't think the jurisdictional argument, I think, is cold logically, but I don't think it was going to stand up.
Is there another problem too, which is how you get information to make the judgment about impeachment? If the person who is under suspicion is also the one controlling access to information.
Well, not if a government order, not if a court orders them to fork over the information.
Yes, but that was the whole problem with the tapes.
What?
Well, it was, how do you get one branch of the government to order?
No. The problem with the tapes was that one branch of government was suing itself.
Well, yes, but I mean, once the Supreme Court got involved, ultimately, I'm saying.
Well, any court got involved.
Right.
Once a special prosecutor, who was a member of the executive branch, began to sue another member of the executive branch, you're into this dilemma.
But then, would the route have been for the House Judiciary Committee to have sued the president for the tapes, and then you'd have one branch suing another, and then the Supreme Court then would rule? Is that how it should have worked?
Yeah.
But in which case, the jurisdictional argument was only good for the instance of the special prosecutor, but it wouldn't have protected the president from that.
Not from impeachment, no.
But because, I mean, I thought that was the essential problem here, was the access to information where the judgment could be made. I mean, Earl Silbert, we've interviewed him, and he did make that a very strong case, but even he will admit that without the tapes, the case against President Nixon was, I mean, it was not an open and shut case.
No, it wasn't. But I don't see that that's a problem. If an impeachment proceeding is going forward, you have to be able to get evidence to base the decision whether to impeach or not on. And I think there was a attempt by the Irvin Committee to get tapes by subpoena, and it failed. But the Irvin Committee was not an impeachment committee. I think it was just sort of a freelance rummaging about. I'd have to go back and read the opinion again.
Well, we got into this because as sort of as a preface to talking about what happens when the Stennis compromise fails, and you find yourself pulled into this crisis.
It was funny because I was watching it, and the radio reported that it had been resolved by compromise. And I called Elliot and said, "Congratulations." He was very glum. He said, "Mr. Cox is not going along." And when they met at the White House, there's a dispute about who. I wish Elliot had taken me to that meeting as he did to the Agnew meeting, because they screwed it up at the White House, both Elliot and the White House. The question came up about issuing an order to Cox, and somebody said, "What will Cox do?" And Elliot apparently said, "He'll resign." Well, I wish I'd been there to say, suppose he doesn't resign. What next? Well, what next is the Saturday Night Massacre. Elliot later said he regretted maybe he hadn't made it clear enough to the president that he could not fire Cox, because that was when the disaster set in. And it's true that he couldn't, for a variety of reasons, one of which was he had given Cox a charter, which he himself drafted, that said he wouldn't fire Cox. Well, that hemmed him in considerably. But they went ahead on the theory that Elliot was going to fire him. And when it turned out Elliot wouldn't, they were stuck. So they turned to Reckel's house, and he wouldn't. So they turned to me. And I remember when I was sitting in Elliot's office, Cox had just given this nationwide color TV speech about why he was going to. It was a theatrical speech, and Elliot's secretary appeared in the doorway and said, "The Attorney General wants to see you." And I went in, and Reckel's house and a couple of young aides were there, running around, and we discussed it, and nobody could see any way out. And Elliot finally said, "I can't fire him, Bill, can you?" And Reckel's house said, "No." And he turned to me and said, "Can you fire him, Bob?" And I said, "Give me a minute to think," because there may be people whose minds are so clear that they can pierce through the fog of all these messes right away. I'm not one of them. It seemed to me there was a big buzzing confusion going on, and I had to get it straightened out in my mind before I knew. So I paced around the room while they continued to discuss things. And I finally said, "I'll fire him, but then I'll resign." And they said, "Well, why would you resign?" They said I shouldn't, because the department needed continuity. And I said, "Because I don't want to be viewed as an apparatchik." Well, the truth is I was the third in line. There was nobody behind me. the Department Regulations and the Attorney General, Deputy Solicitor General. That was it. And if I had resigned or I refused the order and been fired or whatever, an acting Attorney General would have been appointed. Would have had to be somebody from the outside, because after Elliot and Bill and I quit, nobody was going to take that job inside the Department of Justice. And I think probably would have been Fred Bizard. And because those guys wanted to wipe out the entire Special Prosecution Force. After I fired Cox, some people wanted to know why I stopped there. I said, because I ain't going to get involved in an obstruction of justice. That's why I stopped there. So there was nobody behind me, and I finally thought that the man had to be fired for the reasons we've discussed. And the only reason I wouldn't do it was personal fear of what would happen to me. I don't mean I was going to get put in jail, but my reputation would be shot, I thought, for good. I went down and called my wife, who had no inkling of this, and said, I think I may have to fire Archibald Cox. If you've got something to say it now. She said, call Alex Bickel. So I called Bickel. He was out playing tennis. That was that. I went back and told, and Kay called me, and I said, send a car over. And he did. And I went downstairs. It was getting dark, and there was a driver, Len Garment, in the front passenger seat, Bizart in the rear seat. They were afraid I was going to back out, and they were going to grab me, I think, and try to. It looked funny, because they looked like we were going for a ride, I went over and I talked to Haig, and I said, I'll do it, but then I'll resign. He didn't look like he was too interested in whether I resigned or not. And Bryce Harlow was there, and Charles Allen Wright, and the whole crew was there. And Charles Allen Wright said, I'll write the letter. I said, make it terse. And he did. It was a one-line letter. And then after that Nixon wanted to see me. And I went in and chatted with him. He was very gloomy. It was not an outcome he wanted. But I think if it hadn't happened then, it would have happened sooner or later. There was no way he could turn it. The U.S. Attorney's Office or the Special Prosecutor's Office, one of the two was going to get him.
Let's step back a minute. What had you been Attorney General that week before this happened? What might you have done differently? You don't think that this could have been avoided? I guess.
Well, it could be delayed, but had I been Attorney General, I would have had to say, I can't fire Cox, because I've given him a charter. I can't now say the charter is meaningless that I wrote, and I'm firing you. I said, so I can't fire Cox. At that point, it's up to the president what he's going to do, and he can fire me or he can go along. But it would only be a holding action. Sooner or later, that conflict was going to rise to the top.
Since you...
I can see why, people forget why Nixon was had his insecurities, as we know. And one of them was the Kennedy family, whom he regarded as tough and unscrupulous people. And when Cox was sworn in as Solicitor General, Irwin Griswold, and this is another reason I don't think Griswold's a great lawyer, had the swearing in take place in the Solicitor Office of the Solicitor General. No, you don't. The Solicitor General doesn't preside over the swearing in of a guy who's supposed to get the president. And the Kennedy and his family were there at the swearing in, because Cox was a Kennedy family lawyer. He always was who they turned to at Harvard for what testimony, whatever they needed. And he was known as a Kennedy family appendage. So Nixon was paranoid about the whole thing, and he was determined to get rid of Cox sooner or later. And I think he thought that it would have changed the outcome, because I remember talking to Haig. Well, after getting rid of Cox, I was acting Attorney General for 2.5 months. And finally we decided we had to have another special prosecutor because this thing was not flying politically. It was interesting because my staff and I went down the names of all the former presidents of the ABA. At first I was just looking for a good prosecutor. But then I realized that wasn't going to be enough. Had to be somebody well known to whom the press could turn and say, what about this guy? And he would get a good write-up from his colleagues. So we began to look through well-known lawyers, not Hollywood types, but solid. We went down the list, and it's amazing how many members, the presidents of the ABA would not do. Either over age or not very bright. And the one we came up with was Jaworski, and at the same time the White House came up with Jaworski. Now people think that one of the other told the other what to do, but it's not true. We all came up with Jaworski, and I called around. The lawyers I knew all said Jaworski would be fine. And he was. But Haig said, at last we're going to get a pro in here. That's good. And I refrained from saying, I don't know why you want a pro. That's the last thing you should want. Because by that time I thought the thing was going down. And Jaworski came over. He went to see Haig, then he came over to see me and Henry Peterson. And he, now it requires a little background. When I came down from Yale, the solicitor, the professor with a beard, I was suspect. And I remember when I first got over it, I was standing at a meeting, standing at a reception with Norm Carlson, head of the Federal Bureau of Prisons, and Henry Peterson, head of the Criminal Division. And they began talking about their good days at good old Camp Lejeune. And I said, yeah, I was at Camp Lejeune. And they said, you were in the Corps? Because right away the attitude changed. As long as I'd been in the Corps, it didn't. Well, Jaworski came in with his, handed us this sheaf of resume. He held every position I can imagine. Had president of the ABA, president of the Trial Lawyers Association, president of this, on and on and on. So Peterson and I read it, and Peterson looked up and said, Bob, he wasn't in the Corps. And Jaworski looked mightily puzzled by this, what the hell we were talking about. Don't blame him. But he was the ideal choice from our point of view, not from the White House's point of view.
Could you explain why was he an ideal choice from the department's point of view?
He had a lot of prosecuting experience. I think he prosecuted war crimes trials. Mm-hmm. And so he was unimpeachable reputation. And he was competent, very competent. So he would move the thing along. And that's what we needed. think for a while the White House thought he was going to be great because he was a pro, but maybe they didn't. Maybe that staff didn't believe Nixon had anything in his background. Maybe they thought it was all a put up. I don't know what they thought.
Well, why were you sure that it was almost all over by that point?
Well, I remember Henry Peterson saying to me, Bob, he said, we indict people on less evidence than this. It's true. There were just too many things that looked, and you could feel the tide shifting in the country and in Washington against Nixon. So I was sure when I went to the Supreme Court it was going to go against Nixon.
Oh, you mean the next summer, U.S. v. Nixon?
Yeah, I mean I was sure. Wasn't too long after I fired Cox that I began to think that Nixon was going to lose.
Because you knew the situation the White House was in, did that not make you doubt a little bit staying around? After you did fire him and you did not resign.
Well, if I resigned, it would look like I was admitting something was wrong, that I'd done something wrong. I didn't think so.
But you found yourself in a position where you would have to defend the administration.
I didn't. When did I defend the administration?
No, that you would have to. No, that you did. But that it just put yourself in a position where you might have to defend it.
No, not at all. I got a call. They got James St. Clair as their chief defense attorney. And I got a call one day to come over to Haig's office. And I went over, and there was St. Clair and Haig and Bazart and Garment, And Haig said, Bob, the president wants you to argue his case in the Supreme Court on the tapes. And I said, I can't. I said, well, because Jaworski's a member of the Department of Justice. And I have been on his side. I have necessarily been on his side. And if I then switch sides and oppose him, my next argument is going to be before the Character and Fitness Committee of the Illinois State Bar as to why I shouldn't be disbarred. I can't start arguing the case on both sides. And St. Clair then said, this is where I kind of lost some respect for St. Clair. He said, Haig walked away muttering something about technicalities. And St. Clair leaned over and said, I think you're right. I said, well, tell him so. He said, maybe I will someday. Well, that struck me as not the most stand-up position I'd heard in a while.
Just so we're clear, you felt that it was right to fire Cox because the president had the authority to do so.
He had authority to do so, and I thought he had good reason to do so.
Because of the press conference?
Yeah.
But not because of Cox's, anything else? So
no.
Solely because of the press conference?
Solely for making it a national political showdown between himself and the president.
So had this crisis occurred, had he not done the press conference, and you'd been faced with the same problem, same question, you might have had a problem then?
No, I couldn't. Once the special prosecutor was a member of the Department of Justice, which he was in the beginning, I could not oppose him. I mean, I could oppose him in an argument in Elliott's office and saying you shouldn't do that, but I couldn't go into court and oppose him formally.
So I'm just to be clear, but if Cox had not given the press conference, you would have had a quandary had you been asked to fire him.
Yeah, I suppose so. I don't know.
Because Nixon wanted to fire him well before the press conference.
Oh, yeah, but there was no reason to. Nixon had a reason to. I didn't have a reason to.
So for you, that was the press conference?
For me, it was the showdown a political showdown in public between a minor officer and the president.
The White House thought that it had also closed the Watergate Special Prosecution Force. And in the news coverage of the period, there's some confusion over whether or not that office had been abolished or not.
It was abolished. I abolished it.
But it didn't. It didn't.
I reestablished it.
No, simultaneously, right?
Oh.
Well, how long was it abolished? Because
until Jaworski came aboard.
Well, that group, you didn't disband them.
No, they stayed. All that happened was they now became formally Department of Justice attorneys and not identified as special prosecutors attorneys. Nothing changed in what they did. In fact, I met with Lochinvar and Ruth and Peterson. I think it was a Monday after the massacre. I remember the building was dark, and we were pretty much alone in it. And that led me to think, on recalling it, that maybe it was Sunday. But somebody else said it was a holiday. I can't remember what holiday it was. Anyway, what were we discussing?
I asked you about what happened to the Watergate Special Prosecution Force in that period.
Nothing happened to them. They stayed in the building. I went and talked. Peterson and I went over and talked to them. I said, you stay in these offices, continue doing what you're doing, but now you're no longer known officially as the Watergate Special Prosecution Force. That's all that changed. And then when Jaworski came in, and there was a new special prosecutor, there was no special prosecutor. It was hard to have a special prosecutor's force with no special prosecutor. When Jaworski came in, we reestablished it as a special prosecution force, and I issued a new charter.
During that period of, I don't know how long it was, 2 weeks or so, between these two moments, what did you do to make sure you didn't put yourself in jeopardy of an obstruction of justice charge?
I told them to continue with their investigation. What more am I supposed to do?
No, you had just mentioned earlier that you avoided firing them.
Oh yeah, at one point somebody over there, I forget who it was, a couple of them, you get a special prosecution force. What you do almost invariably is get enemies of the person being investigated, and they want to get them. They want to indict. In Nixon's case, it clearly did, but I've seen it in other cases too. So that I think I'm having trouble. It was Monday, and they came over, and we sat in my office, and I told them that I wanted them to go forward, and at one point I said, I hope you have some good cases, because if you haven't got any good cases, this could look like an obstruction of justice. As if I fire Cox and the whole thing collapses. And Lochinvar said, we have good cases, and he designated a man of considerable seniority, he said he had a case against. And for some reason, Peterson exploded at that point and denounced Lacavara, although Peterson didn't like the guy that Lacavara was talking about. I don't know what the hell that was about. Maybe Peterson's nerves were just stretched thin. That was very tense times. But I went on my way not to interfere with or influence in any way any decision they made about. Now, if they started, violating their charter in some egregious fashion, I would have had to do something. But they didn't, and I stayed the heck out of it.
In that first week, the president, in a speech, said that he would not give his materials to any prosecutor. But then a few days later, when you talked about Jaworski, you said Jaworski would have the opportunity to seek whatever materials he needed.
Opportunity to seek it, that's right.
Any tension or pushback from the White House? Did you talk to them in between?
Well, at one point, somebody asked me, if you're going to let these things go on, what's the point in firing Cox? I don't know. The point is to stop the investigation. And Nixon said he was not going to turn him over, but that's not inconsistent with the special prosecutor's power to seek them.
Whose idea was it when President Nixon, I think you mentioned this, that with Jaworski, President Nixon undertook that he would not fire Jaworski unless he had met with a bipartisan group.
Oh, yeah, that was...
Where did that come from?
Nixon or Haig, or Brizard, I forget. But, oh, God, that's so stupid. I told the people that, I said, the charter has to be identical to the one Cox has. You can't take away any powers that Cox had, just not in the cards anymore. I don't care how badly that thing is drawn, we're not going to redraw it. And somebody said, we'll give an additional assurance to Jaworski by saying that he had to go to, I forget the speaker of that, anyway, he had to get unanimous approval from a group that included partisan Democrats. It wasn't going to get, in order to fire. Mm-hmm. So Teddy Kennedy immediately announced that I was planning to fire the new federal prosecutor, and I had provided for the mechanism by which I could fire him by putting that into the charter. And I was called up before the Senate Judiciary Committee, and I pointed out this is idiocy. If I were planning to fire a special prosecutor, I would not make it impossible by giving a veto power to a bipartisan commission, which has to be unanimous. And the press was all excited; they were going to get something out. Then when they heard what it was all about, they closed their notebooks and went home. But Kennedy was doing his best to. Although it was a silly best, because there was no way you could convert that kind of a guarantee into a threat. And in fact, Jaworski told him he wasn't worried. Jaworski told him it was all right with him. Nevertheless, they went ahead and screamed for a while.
But the idea had come from the White House, right?
Yeah. Well, that's right, but somebody was trying to show how pure they were.
Now, during this period, the White House changes its position completely on the tapes and decided to give them up.
Yeah.
Did you participate at all in that discussion?
No. Why would I?
No, but I didn't know the extent to which they were talking to you. And
I was not eager to talk to them. You know, when they called, I'd talk to them, but I was not eager to insert myself into their deliberations, because I could imagine what those deliberations were like, probably highly confused.
And a new Attorney General starts in December of '73. What were your relations like with William Saxbe?
They were very cordial. William Saxbe is a very funny guy, you know?
No.
Very down to earth. He chewed tobacco all the time. And he had a coffee can in which he didn't spit into it, he drooled into it. Sitting in the Attorney General's office, he would lean over and drool. And in the limousine, when he and I were going someplace together, his limousine, he had the coffee can on the floor of the limousine, and he would drool tobacco juice into it. And I remember the first time I went in to talk to him, to try to explain the department to him. He did that, and I found it pretty disgusting. So the next time, I was going in with the entire head leadership of the Department of Justice. And as being senior, I should go in first. But I'd been there before. So I insisted they all go in first and sit on the other side of the room, because I knew which way Jaworski, Saxbe faced when he did this routine. And I wasn't going to be facing it. So they got in and I sat to the side. But he was he was kind of charming. He didn't take the job seriously at all. He traveled around the country doing what he called job owning for justice, by which he meant he went on hunting trips and so forth. And the department's business was run by next level down. Larry Silberman, who was then Deputy Attorney General, when they had a big meeting in his office, and there was as there often was, conflict between different branches, different parts of the government, and you had to adjust them. That was a routine occurrence. He would, when it got really serious, he would say, "Well, this is one that has to be taken up by the Attorney General. It's too serious." And he would then leave the room, leaving them sitting there, walk down the hallway, go into the elevator bank, smoke a cigarette, come back and says, "The Attorney General says," you know. That's the way Saxbe ran it. He had staff meetings. Well, we all had staff meetings, the entire department. The leaders of the department. And we all had something to say. It may not be earth-shaking, we had something to say. Saxbe would open the meeting and look around and say, "Well, bar's open." And that was it. We would all go over and get a drink. And that was the staff meeting. Never varied.
What were your principal concerns the first 9 months of '74? I mean, in 1974, your Solicitor General, before President Nixon resigns, what were your principal concerns those months?
When I was Solicitor General, but not Attorney General.
Yeah, when you were back.
My principal concerns were arguing the cases I had. The first day back, during the time when I was acting Attorney General, I had no staff. I mean, Richardson's staff, Bickel's staff, everybody had left. So nobody was writing memoranda, putting things in context and so forth. And I had Ed Kitch and Bill Enright, two guys from my own office, sort of scurrying around trying to straighten things out. And I sat on a couch and received people and sort of dispensed justice offhand. It was ridiculous. But the first day back, when Saxbe took over and I went back to the court, I was sitting there, and just before the court adjourned, the Solicitor General sits up front. Just before the court adjourned, a page handed me a note, and it said, I want to throw a lunch in your honor. The other members will be the members of the court. Please let me know. I couldn't read the signature. So I waited. Somebody up there invited me to lunch. So I went up to the clerk of the court afterwards and said, "Who is that?" And he says, "William O. Douglas." And that was extraordinary because I had written many vitriolic articles about William O. Douglas. And he knew it. I mean, you know, the people like that know what's been said about them. So I went up on the appointed day, and Douglas was not a spendthrift by any means. But he was there Douglas was standing there with a bartender and a bar and a table fully for the court. And the first thing he said was, "There's no business purpose to this meeting. I just want you to know you've got friends in this town," which astounded me. But then at the end of the lunch, when everybody else had left, he had stayed behind and said exactly the same thing again.
What was the meeting with the Watergate Special Prosecution Force like that night, way back on the night of Saturday Night Massacre? You met with them, or the next day you met with them? The next day?
No, I met with the leaders the next day.
Did you not meet with the whole staff?
Yeah, but not the next day.
Oh.
I think sometime during the following week, I guess. What was it like? Well, a little bit tense. But when I walked in with Peterson, I said, "I'm willing to discuss anything with you about your work or anything else, but I'm not going to argue with you about whether I should have fired Cox or not. That's just, I'm not going to discuss it with you." You know, I could see the thing breaking down into a series of accusations and arguments and so forth. So they shut up about that. And you know, they asked me if they could go to court for tapes, and I said yes. And we did some other things like that, and that was it.
Did you see President Nixon in 1974 at all?
I can't remember. I saw him last at a cabinet meeting where, being acting, I sat in, and that must have been close to, because I think Saxbe must have come in about January 15th, somewhere like that.
You didn't.
And I don't recall seeing Nixon offhand once Saxbe came in.
What effect did Watergate have on the work you were doing in 1974 in those first 9 months? I mean, the administration is collapsing around you.
We weren't collapsing. The Solicitor General's office wasn't collapsing. No. Alex Bickel said to me, he was the best friend I ever had, and we were talking on the telephone, and he said, "Get out of there, Bob. Resign. Get out of there." And I said, "Why?" He said, "Because the whole thing is going to come down. The whole thing's going to collapse. It's apparent that they've been running a political intelligence operation out of the White House, you know, tapping enemies and so forth." Well, I didn't do it. We kept on doing what we did. It was fine. You know, what were they going to do? Tell us not to file any briefs in the Supreme Court or something? Ridiculous. One thing, I was untouchable, because once I fired Cox, the administration couldn't touch me. as if I went overboard and denounced them. It was a blow they were unwilling to take. In fact, when Saxbe came in, he was told that he could fire anybody in the office but me. But I wrote out a resignation statement, rather generic, didn't refer to any specific event, but just said things had been requested or something that I couldn't go along with. And I carried it in my breast pocket, prepared to whip it out and resign at any moment, because that's the way things felt around there at that time. And Henry Peterson, when he found out, said, Bob, he said, don't even bother checking with me. If you find you need to pull that thing out, resign for me too. Well, I got a lot of pressure at one point about some stupid oath on a passport that they wanted. Everybody in the right wing was going crazy about the ruling that you take the loyalty oath off the passport. And I kept getting calls from the White House about calming these groups by asking for appeal in the Supreme Court. I said, if they allowed the appeal, I don't know what the hell I'd say, because I'd be wrong. And I'm not going to go up there and make an argument that I know is a disaster. And they pressed me again. I said, look, I don't mind being out in the street anytime. If I could find a reason to resign, I didn't say this to them, but if there was a good reason to resign, a lot of people would have forgiven me for my sins.
Do you think that the fact that you had this immunity allowed you to defend Jaworski's independence more successfully than you might otherwise have had?
Yeah, I think so, but I didn't really, it was never really tested. Well, it was. They asked me to fire a couple more guys. Well, somebody got a tape and was taking it around to cocktail parties and playing Nixon's tape at cocktail parties. And they wanted to fire him, and I said, well, he deserves firing, but I'm afraid that if I start firing anybody else, I'll get mass resignations, and that will look like a obstruction of justice. So let it go, and they did.
What was your reaction when you heard the smoking gun tape?
Dismay, but not surprise.
Could you develop that a little?
Well, I was sorry to see the last nail hammered into the coffin. For an administration that looked so hopeful so recently. But I was not so terribly surprised that there was a smoking gun. Jaworski called me before they went to court and said, we're going into court in about 5 minutes. I'm going to tell you that there's an 18-and-a-half-minute gap in the tapes. Well, that surprised me and dismayed me.
Well, that was back in '73.
Yeah, by that time, well, you can't sit around with 18-and-a-half-minute gaps showing up and not beginning to suspect something.
This is a parochial question, but did you? There was a big case when the president, now the former president, sued the General Services Administration, which includes the National Archives. In those days, the National Archives wasn't an independent agency, over his property, over his tapes and his papers. Did you support the Ford administration? President Ford signed something called PRIMPA, the Presidential Records Act, Presidential Records Materials Preservation Act.
I don't think that got to the courts during my time.
No, it didn't. It got to the court just after. It got to the court in '77, just after you'd left. But we were talking about Griswold and how maybe he wrote the Milliken brief. I didn't know if you'd done the brief for this particular case.
No. Nope.
Did you, during that very tense moment on, I guess it's on the Saturday of the massacre, did you use the term murder-suicide?
Mm-hmm. I have an unfortunate habit of saying things like that.
Do you want to recall it for the...
No, they wanted... somebody wanted Richardson to fire Cox and then resign. And I said, it's murder-suicide. Wasn't any big deal, but unfortunately, if you put things in a faintly colorful fashion, they get remembered.
But what makes this funny, is that, do you remember, or is it true that when you said that you would then fire Cox and resign, Elliot Richardson turned to you and said, but Bob, that would be a murder-suicide?
I don't recall he said that. He could have. But I recall he said, don't do it. Don't resign. Because the department requires continuity.
Jonathan Moore recalls that you said I can do it because I also don't agree with what Cox has done.
I know Jonathan Moore says that. And it's not true, and it never has been true. He said that 5 years ago, someplace he was making a film for the Discovery Channel. And he said that, and then nobody else recalls that. And I think it's a form of revenge for the killing of a father figure. I don't know.
Okay, we'll be able to finish in 2 minutes. What did you think of, you thought that the Supreme Court would rule against Nixon in the case of U.S. v. Nixon. You came to that judgment based on the political temper of the times?
Yeah.
If the House, though, if the House had sued for the tapes, could you have seen a judicial argument for some judicial review of presidential materials?
What I've seen,
I'm just. Could you have seen a judicial argument for President Nixon handing over the tapes to Congress?
being forced to.
Yeah.
Yeah.
Last question. Was Hillary Clinton your student?
Who?
Hillary Clinton.
Hillary was, Bill was, Robert Reich was, Anita Hill was, Jerry Brown was. I had a great record.
Well, just to put this interview into context, today she was nominated to be Secretary of State.
Yeah, well, some things can't be helped. I also had, in my defense, I would point out that I had Jack, the St. Louis senator.
Danforth,
and John Bolton, and one or two others.
Did you ever talk to Archibald Cox after the Saturday Night Massacre?
Yeah. Twice. We were at this conference in London about the Saturday Night Massacre, which is where this Jonathan Moore sort of thing surfaced. Then later on, he and I both testified against a bill which was proposed to change the meaning of human life by statute so that Roe against Wade would be overruled. The human life began with conception, and therefore due process clause means that you can't approve of abortion. Well, I think that's a nutty legal argument, and Cox thought it was, for different reasons, was wrong. So we both testified against the bill and sat side by side and discussed it.
What did he say to you about the Saturday Night Massacre? If he did. Not in the second instance.
No, he never did.
What about Elliot Richardson? Did he talk to you about this event afterwards?
I don't know, he talked to me. He testified on my behalf about it at the confirmation hearings for the Supreme Court. No, Elliot was fine. He and I had a pretty close relationship for a while. I don't mean to say that anything went wrong with the relationship. We just weren't thrown together once we got out of the Department of Justice. I went back to New Haven.
Judge Bork, thank you.
Okay, I'm just trying to see whether there was something here I wanted to...
Is there anything? Well, if we can change tapes and...
We'll keep going. I haven't gotten a warning yet.
Okay.
Probably not, but I'll just take a quick look.
Sure.
I'm going to stop rolling right now.
Save this, but when Nixon said, I guess you have to indict Agnew, he then said, if you got to do that, you got to take a look at, and he began naming the Western District of Ohio, the Eastern District of Idaho, because in addition to an encyclopedic knowledge of law and foreign policy and so forth and so on, he also had an incredible knowledge of local politics, which I suppose helped him a great deal.
I told him that smoking was fine, that it would give an element of film noir to this, which... and I meant it.
No, you said you read the Agnew brief, huh?
Mm-hmm. No, I may not have read it well, but I read it.
Good question. Did you specifically tell the Nixon defense that they should consult with Bickel on cases of controversy? Because he had written that article in the New Republic.
I don't think I told them to consult Bickel. I probably pointed the article out to them. But
thank you, Charles. You mean during the Saturday Night because Bickel...
Before the Saturday Night Massacre,
yes.
That summer, Bickel had written an article which was called Tapes, Cox, Nixon in the New Republic.
that's the argument about no jurisdiction because people in the same branch of government are suing each other.
Right.
And Bickel first wrote this up in the New Republic.
Yeah, but according to what you said before, St. Clair never bothered to pick it up?
Who did?
St. Clair.
He picked half of it up, but when somebody... He said that much, but when Potter Stewart said, yes, but here the man has a charter, the answer to that is, what difference does that make? You still have people in the same branch of government suing each other, and if you want to do that, the president can cover the landscape with charters, and you fellows can sit here and decide disputes between the Secretary of State and the Deputy Secretary of State. But that's why I think that St. Clair didn't really understand the argument, because he just repeated the half, and then when...
The president has more absolute power.
Pardon me?
The president has more absolute power. The charter didn't limit the president's ability to do something.
Well, not just that. That's right. It doesn't. And I don't know if the president's having absolute power, but the fact is, if the charter made that much difference, as I say, you could change the entire form of our Republican form of government just by issuing charters.
Yeah. No, right. Yeah. you could actually invalidate the Constitution.
Yes.
All right. Well, I think Charles made a good point. Do you mind if we Did you find an issue you wanted to?
No, I don't think so.
Can I ask you about the? I should have asked you about the Bickel article. Is it okay?
Sure.
Thank you.
I'll get you later.
Judge Bork, in the summer of 1973, your friend Alexander Bickel wrote a piece for the New Republic. Did you talk to him before he wrote the piece?
No.
Tell us about the piece and what effect, if any, it had on events.
Well, the piece simply pointed out that the Constitution required a case or a controversy before a court can hear the dispute. If the dispute is between two members of the same branch of government and it can be resolved by one giving the other one an order, there's no case or controversy. It can't be a case or controversy. And in fact, it's worse than that because you're changing the Republican form of government by inserting the judiciary into political disputes within branches of government. And Bickel made that point in an article. Seems to be irrefutable. I read it. I think I probably discussed it with him then. And I told Al Haig about it. And I guess I told St. Clair about it. But the fact is, it had no effect on the course of events. Partially because St. Clair didn't understand the ramifications of the argument, but also perhaps because it didn't matter in the hydraulic pressure of the case, which is the way Holmes put it once. There was no legal argument was going to stand against the determination to have done with Richard Nixon.
Do you think that some of Richard Nixon's use of executive privilege, the term, governmental privilege is what it really was, as you mentioned, or even national security as a way of protecting access to his materials, that this undermined those arguments for later presidents?
Yeah, to a degree. That may not, the undermining may not be fatal or permanent, but it certainly didn't do those arguments any good. It's too bad because they are crucial arguments, and people come to dismiss them automatically. Then you lose some vital things.
But if the system is such that the president can use those arguments, what is the check on those instances where they are badly used, as in this case?
Well, I suppose the only way thing you do is have a court, for one kind of thing, appoint a special master to examine the disputed documents and to see whether there was, in fact, a national security objection to their release. Now, that's what we were negotiating with Cox when the Saturday Night Massacre cut everything off. But I think I mentioned to you that there was a former general counsel of CIA whom everybody on both sides agreed was a man of great integrity and good common sense. And we were considering using him as a sort of an arbitrator to look at the documents and decide whether there was a valid national security concern or not. That's the only way I can see around the problem, because I don't think now, for the foreseeable future, it's unlikely anybody's going to just take the president's word for it. On the other hand, it's too dangerous just to automatically discount the president's concerns.
What branch would the special master be from? The judicial branch?
Could be appointed by a court.
But it would have to be outside of the executive branch for this to work, wouldn't it?
Oh yes.
Well, I have asked you all the questions I had to, and I'm very appreciative to you for your time.
Well, I enjoyed it. Thank you. The one difficulty is that after you leave, I will think of 7 things that should have been said. But
well, Alexander Bickel finished playing tennis, so you got to talk to him afterward. Did he tell you what he would have said to you had you reached him that night?
yeah, I think he agreed with me that the institution had to be protected, and the firing Cox was essential to that. He disagreed with me. He thought Agnew should be immune from prosecution. We argued about that. Bickel and I taught classes together. We argued all the time.
Thank you. Thank you.